There's a lot of breaking news tonight, and specifically there is breaking news that Donald Trump has privately expressed serious interest in deploying U.S. troops on the ground inside of Iran. And that's brand new reporting from NBC News, according to two U.S. officials, a former U.S. official and another person with knowledge of the conversations. That is a lot of people providing this information to NBC. Trump has apparently discussed the idea of troops on the ground with both aides and Republican officials outside of the White House. And I just want you to think about that incredibly sobering news in the context of what we are seeing and hearing from this president publicly right now. Because today, the president who just launched the United States into a war with Iran just 7 days ago, and who is now apparently expressing interest in sending U.S. ground troops into that war, which is, of course, the fear that millions of Americans, people with children, people with grandchildren.
But here's where it gets even more intriguing. While the political world fixates on polls and rallies, there's this other reality quietly unfolding behind closed courtroom doors. It's a separate universe where everything is methodically building, a situation that Trump and his legal team might not fully grasp or prepare for. Within this hidden world, there are sealed court filings, sealed evidence packages, grand jury transcripts, and FBI interview notes. Judges are reviewing all this information privately, away from the cameras and political drama, and it's packed with detailed sworn accounts of Trump's actions that the public hasn't seen before. This isn't about hearsay or speculation. We're talking concrete legal filings and court records that are quietly piling up. They're creating one of the most extensive hidden records about any American president's alleged criminal activities. The key question for anyone following Trump's legal troubles isn't whether this record actually exists, because it does. The real question is, what's going to happen when all of this starts to come to light?
Hosted a roundtable for college sports officials today, where he seemed, well, laser focused on how to fix what he called the mess of how college athletes are paid. And even to Fox News reporter Peter Doocy, my old buddy Peter Doocy.
It sounds like the Russians are helping Iran target and attack Americans now.
That's an easy problem compared to what we're doing here. I mean, but can I be honest? It's just, I have a lot of respect for you.
Today, he hosted a round on college sports where he seemed really focused on untangling what he referred to as the mess surrounding how college athletes are compensated. He even chatted with my old buddy, the Fox News reporter Peter Doocy. He made an interesting point about how it seems like the Russians are helping to target Americans. Then he casually mentioned, that's a simpler issue than what's happening here. Then he shifted gears and wanted to set the record straight about something. There's been a lot of chatter online with sensational headlines claiming prison is absolutely unavoidable, that judges have already issued sealed verdicts, and that it's all over for Trump. I get it. That kind of framing goes viral because the whole situation is quite serious from Trump's legal standpoint, and the drama makes for great headlines. However, here's the thing. Overstating the situation does everyone a disservice. In reality, no judge has declared prison as inevitable, and there's no sealed verdict just waiting to be released. What's really unfolding is a significant amount of sealed evidence, findings, and legal arguments that judges are currently reviewing, and prosecutors are geared up to use it. This all maps out Trump's alleged criminal behavior in detail, which could factor into upcoming trials, sentencing, and appeals. That's the real story right there. And trust me, it's more than enough to keep you engaged for the next 25 minutes. So let's take a look at what's going on inside Judge Tanya Chuk's courtroom concerning the federal election. So there's this interference case that's really heating up, especially because of the sealed evidence involved. Special counsel Jack Smith submitted a package of sealed evidence to Judge Chutkan, and this contains grand jury transcripts, notes from FBI interviews, and documents from key witnesses we all know like Mike Pence, Ivanka Trump, and Mark Meadows. We're talking about sworn testimonies from people who were right there during those tense days after the election. Their testimonies lay out in detail exactly what was said, what decisions were made, and what Trump knew during the crucial weeks from Election Day to January 6th. The prosecutors told the court that this sealed brief features sensitive and previously unseen evidence that aims to sustain their revised indictment against Trump, especially in light of the Supreme Court's ruling on presidential immunity. That's the legal side of things. But what it boils down to in simple terms is that Smith has documents the public hasn't seen yet. Evidence that judges are currently reviewing privately, potentially outlining Trump's actions in a way that's crafted to hold up against his team's strongest defenses. It's almost unbelievable, right? This isn't just a side note. This is central to a prosecution that's very much active, even if the political landscape has slowed things down a bit. Then in October of 2024, Judge Chutkan gave everyone a little peek behind the curtain by unsealing nearly 100 to 900 pages of documents in the election case. These documents, even with some redactions, provide a significant insight into the evidence Smith plans to bring to trial. What came out in those pages was enough to make legal analysts spend weeks poring over it. We saw detailed accounts of what Trump knew, evidence of his intentions, and grand jury testimonies from those closest to him about what he was told and how he reacted. And here's the kicker. The 1,900 pages that were unsealed were deemed the portions that could go public. The stuff still locked away behind those sealed doors is the material judges ruled was too sensitive, classified, or important to share with the public just yet. It's a lot to think about. It's really interesting to think about what could still be hidden away in that sealed package. If what has already been revealed is so detailed and damaging, just imagine what's still out of sight. This situation is pretty wild, and I can only guess how much Trump's legal team is stressing over this right now. Many people don't quite get what sealed really means until they think it through. Sealed doesn't mean the information is gone or stops being important. It simply means that judges are reading it in private and prosecutors are using it in documents that aren't public. It's just sitting there in the legal system, waiting for the right moment to be brought out into the open during a hearing or trial. When that time comes, whether it's 1,900 new pages getting unsealed, or evidence being presented in court, or even during sentencing where a judge has to consider everything known about a defendant's behavior, suddenly all that sealed information becomes public and can be cited in legal discussions. Everything that has been gathered so far, every transcript, every exhibit that's been validated means that Trump's opponents don't need to start from scratch. They've already built their case behind closed doors with these sealed filings, and it's advanced further than most people realize. Now, if we dig deeper, we see that this sealed evidence situation isn't just about one case or courthouse. It actually covers several legal proceedings, judges, and jurisdictions, each contributing to what's turning into a pretty thorough hidden record of Trump's alleged misconduct. Understanding how these pieces fit together is crucial. They can link evidence from one case to support another, and findings from one court can serve as a guide for prosecutors and others. The whole situation is much more interconnected than one might think, making it harder to manage than if it were just an isolated case. This sealed evidence dilemma represents a significant long-term legal challenge for Trump, especially in today's political landscape. Let's start breaking down the specifics, beginning with the documents case. It's pretty remarkable how sealed materials are connected to classified national security info, and it's clear that the restrictions on Trump are quite unusual and significant. We're looking at the Mar-a-Lago case, which revolves around Trump holding on to classified national defense information after he left office. The court has already established findings that led to 40 felony counts against him, and they've set strict protective orders on how the classified materials can be handled. What's particularly striking is that Trump can only view the most sensitive documents under the supervision of his attorneys and in a controlled environment following specific conditions laid out by the court. Just imagine that a sitting president has to operate under a court-sued protective order that limits his access to classified materials because those materials are now part of a criminal case against him. There's really no precedent in American legal history for something like this. The sealed filings in this case, which include motions, exhibits, and classified attachments, can only be accessed by cleared attorneys in the judge. These documents serve as the basis for the 40 felony counts linked to some of the government's most sensitive national security information. This material exists, has been validated, and is officially part of the court record. Just because it's currently sealed doesn't mean it will stay that way forever. It's just biding its time for the legal process to decide when and how it becomes public. And we can't overlook Jack Smith's final report, which is another important piece of the sealed evidence puzzle that often doesn't get enough attention in discussions about Trump's legal troubles. After his investigation, Smith submitted a detailed report that lays out his findings regarding Trump's actions in both the election interference case and the documents case. Trump did everything he could, battling through extensive legal challenges to keep that report under wraps, but he didn't succeed. The report was released, and it goes into great detail about the criminal behaviors Trump exhibited across various areas of the investigation. Legal experts who have analyzed how these reports fit into the broader legal context emphasize how significant they are to understanding the situation. It's fascinating how the final report goes beyond just making waves in the public eye. It actually has serious implications for future sentencing. When it comes time for a judge to decide on a sentence for someone, they aren't just looking at the specific charges the defendant was convicted of. They have to consider the whole picture of the defendant's actions to fully grasp what took place. This is where Smith's final report comes in. It's thorough, well documented, and provides a comprehensive look at Trump's actions. This kind of report is exactly what a judge can refer to in order to understand the wider context of his behavior. It's not just a political document. It's a legal piece that could play an important role if these cases go to sentencing. Now, let's dive into something that doesn't get as much attention, but is really crucial in Trump's legal saga. It's how judicial findings in one case can actually serve as a guide and support for prosecutors in others. This mechanism tends to fly under the radar of mainstream political discussions, but legal analysts who keep an eye on these cases know it well. When Judge Chutkan looks over the sealed evidence in the election interference case and makes a ruling, whether it's about what can be admitted or what the updated charges should be, that ruling holds implicit findings about Trump's conduct. It gives insight into how the judge views the evidence and the legal standards at play, along with how Trump's defenses stack up against the specific facts. And here's the kicker. These findings become part of the public record as soon as they are issued, even if they come from procedural rulings instead of final verdicts. Prosecutors in other cases can reference them, and other judges can use them as a framework for future trials, sentencings, or appeals. Those prior judicial findings help shape the legal landscape, impacting what arguments can be made and their strength. Each time a judge makes a ruling that sheds light on Trump's intent or behavior, it adds another layer to the legal record, making it increasingly difficult for him to evade accountability. It's this slow, methodical, and often unglamorous process that shows how the law can gradually tighten its grip on influential individuals rather than doing so in one dramatic swoop. There's a buildup of findings and rulings that have developed over time, and it's crucial to talk about the specific witnesses whose testimonies are included in that sealed evidence package. The names and the context really help us understand why this evidence is so important. First, there's Mike Pence, the former vice president. He was right there during the January 6th events inside the Capitol when the attack occurred. Trump was pushing him both publicly and privately to reject the electoral count, and Pence has been pretty wary of his relationship with Trump since then. His grand jury testimony is part of that sealed package, and it gives a first-hand account of what he saw and experienced during those critical days from the standpoint of the second highest official in the country. Then we have Ivanka Trump, Trump's own daughter who was present in the White House during the post-election period. She also has her perspective on what was happening inside the building during those weeks. And let's not forget Mark Meadows. We've talked about his cooperation before, and his testimony about Trump knowing that the fraud claims were baseless is a standout piece of insider evidence in this entire case. All of this important testimony is sitting in that sealed package, and just because it's sealed doesn't lessen its weight or significance when it eventually becomes accessible in a trial or sentencing hearing. It's honestly hard to comprehend what it means for Trump's legal team to be operating under these circumstances. They know that package exists. So they're aware that Pence's testimony, Meadows' insights, and Ivanka's account are in there, but they can't fully see what's inside. They can't evaluate all the details, and they aren't able to prepare responses to evidence they haven't been able to review in its entirety. That puts them in a really tough spot. They know the evidence is out there. They have a vague idea of what it covers, but the full scope of what the prosecutors have compiled in that sealed record, including specific quotes and details, remains partially a mystery. The legal process is still figuring out when it's appropriate to bring to light the sealed documents, and this creates a tricky situation. The prosecution has a complete view of the sealed evidence, while the defense is left to navigate with limited information. This gives a big advantage to the prosecutors, and that advantage grows over time as more evidence gets tucked away from public eye. With Trump's legal team making decisions without seeing the full picture, you can imagine how challenging that must be. Now let's zoom out a bit, because there's more happening here than just the sealed evidence. This isn't taking place in a political bubble. It's unfolding in a legal setting where questions about Trump's immunity are very much alive. The debate about which actions from his first term might be protected by presidential immunity is still being hashed out in court. While the Supreme Court laid down some basic guidelines, it didn't answer every question. The sealed evidence presented by Smith to Chutkan is tailored to clarify this situation and argue that even under the most favorable interpretation of presidential immunity, the actions listed in the revised indictment aren't covered. As the courts sort through these immunity issues, the relevance of the sealed records can shift, and some of that information may eventually be released. Essentially, resolving these immunity questions will unlock various parts of the sealed evidence package. And this process is slow and mostly happens out of the public eye, but it's progressing regardless of what else is making headlines. To wrap it all up, it's crucial to nail down the most important points since we've navigated quite a bit of legal territory. The sealed evidence, multiple cases, witness stories, and court rulings all connect to what's at stake for Trump's legal future. Here are 4 takeaways to remember about the significance of the sealed evidence, particularly in a climate where these cases seem to be on hold. Let's break this down bit by bit. First off, the way sealed evidence works in the federal legal system is really straightforward once you get the hang of it. It's not a forever thing. Sealed documents are only temporarily kept under wraps because the court needs to weigh what should be public at a certain time during a specific case. This is mainly to protect ongoing investigations, witnesses' sensitive information, or to guarantee that a trial is fair. But here's the kicker. Those sealed documents don't stay sealed forever. They'll be opened up once the reasons for sealing them no longer apply. For instance, they'll be unsealed when a trial begins and there's a need to present evidence, or during a sentencing when the judge needs to see the complete record of what the defendant did. Even appellate courts can decide that certain things need to be public. So all the sealed stuff currently sitting with Judge Chuck Kahn, like grand jury transcripts, FBI interview notes, and documents from Pence, Meadows, and Ivanka Trump, will eventually see the light of day. It's only a matter of when and under what circumstances. The timeline for unsealing these documents is a huge deal in American politics right now. Now, on to the second point. There's something about the way sealed findings can be used across different cases that Trump's legal team just can't fully sidestep, even with the political landscape in play. What I mean is this. One typical defense in any case is claiming that it's all politically charged, suggesting that the prosecutor or judge has it out for Trump, and this taints the legal process. That argument does get some traction, even if it doesn't hold much water legally. But here's where it gets tricky. The fact that multiple judges from various jurisdictions appointed by presidents from both parties reach similar conclusions about Trump's actions using different sets of evidence makes that politically motivated defense harder to maintain. When so many independent sources converge on the same findings, the argument starts to look pretty flimsy. You know, it's really interesting how everything seems to connect when you look at Chuck Kahn's findings on Trump's intent. These findings align with those in Smith's final report, which in turn mirror what we saw in the New York civil fraud cases. It's all tied together by the testimonials from insiders like Meadows and Patel. When you have independent proceedings reaching the same conclusion, it becomes hard to dismiss as just political persecution. It really looks more like several different institutions are arriving at similar conclusions because the evidence they're working with points in the same direction. Now, that convergence of independent corroboration is what makes the sealed documentation such a strong legal asset for the prosecutors in the long run. Let's talk about something I think is crucial, which is the sentencing aspect of all this. It seems like it hasn't been reported on much, but it's significant for grasping Trump's potential legal exposure. So, if Trump is ever convicted in any of these cases, the sentencing phase will be where everything comes together in a big way. During sentencing, a federal judge isn't restricted to just considering the charges that led to the conviction. Thanks to federal sentencing guidelines and existing case law, a judge can look at the full picture of the defendant's conduct. This means everything relevant to understanding what Trump did and the seriousness of it all gets taken into account. Legal analysts point out that Smith's final report, with its detailed examination of various criminal activities, is something that could play a big role during sentencing. All of those sealed evidence packages, grand jury transcripts, FBI interview notes, and documentary evidence are part of what a sentencing judge can access. Plus, the judicial findings from the previous immunity litigation, like what Trump knew and intended, are all pieces of the puzzle for the sentencing landscape. Everything that has been compiled, sealed, and documented holds significant weight, not just for getting a conviction, but even more so for what happens afterward. When a federal judge considers the full range of the evidence during sentencing, they have both the facts and precedents to make some serious decisions. We're taking a step back to look at the big picture and how everything we've talked about ties together with what's coming next. Right now, the sealed evidence includes everything from packages in Chutkan's court to classified materials in the documents case. This whole situation represents the most thorough documented account of alleged misconduct by a sitting president in American history. It has taken years of investigative effort, grand jury proceedings, and the careful planning of seasoned federal prosecutors to put this all together. The evidence is stored in sealed court records, complete with authenticated exhibits and sworn grand jury transcripts, making it tough to shake off, dispute, or wipe out compared to leaked papers or anonymous claims. Sure, the political landscape, like Trump being in the White House, immunity-related lawsuits, and changes in the Justice Department, has slowed down how quickly these cases are moving. But none of that erases the record. It just puts a pause on things. The timeline gets complicated, but the truth remains. The evidence doesn't vanish. The witnesses' sworn statements stay the same, and the documents still tell their story. Future courts, judges, prosecutors, and proceedings can always pick up right where we are now and continue when the time is right. So here we sit with the most crucial legal evidence ever gathered about a sitting American president hidden in sealed court filings, being looked over by federal judges and referenced in private legal discussions. We're waiting to see when and how this legal process will bring it all to light. This record includes the sworn testimonies of the former vice president, the former chief of staff, and Trump's own daughter, all detailing events from within the White House and the administration that clearly show Trump's knowledge and intent. There are 40 felony charges in the document case backed by classified evidence that only authorized attorneys can currently examine. Plus, there's a final prosecutorial report that outlines serious criminal activity crafted in a way specifically aimed at being used during sentencing. Let's be real about the situation regarding those sealed documents and what it all means. Tonight, there's no prison sentence hanging over anyone's head, at least not yet. No judge has handed down a sealed verdict. And honestly, these cases are pretty complicated. The timeline is still up in the air, and the political climate surrounding all this is as unfriendly as it can get. That's the reality, and I won't sugarcoat it. But here's the thing. Thinking that the sealed records don't matter or that the growing pile of evidence can be wiped clean because of the current political climate is just not how the federal legal system operates. Evidence stays relevant. Testimony from the grand jury isn't just going to fade away. Court decisions don't vanish because of shifting political attitudes. Every judge going through those sealed documents right now is diving into grand jury transcripts and FBI interview notes, along with all sorts of documents from people who were close to Trump when those key moments were happening during his first term. They're assembling an understanding of this case that will influence everything that follows, regardless of whether the timing seems good for prosecution at the moment. The record is being created with most of it still under wraps. When the day finally arrives and all this information gets revealed, when courtroom doors swing open and exhibits are displayed in front of juries, it's going to be a pivotal day in both American legal and political history. So keep an eye out. The next unsealing order from Judge Chuck Kahn could be the time when all of that hidden evidence starts to come to light. And once it does, it'll be impossible for anyone to ignore.